I call Melissa Lee.
Thank you, Mr. Speaker. It's a great pleasure to rise to speak on the second reading of the Patents, Trans-Tasman Patent Attorneys and Other Matters Amendment Bill, sir. And before I actually get going on the substantive nature of the bill, I'm just a little bit in shock that I got so many compliments from the member who just actually sat down. And it is actually quite surprising to get so many compliments. And I think I was counting about 4 at least that he actually thanked me. And I thank the member, and compliments are way better than insults across the chamber, and I thank the member for his contribution in the Select Committee process. Sir, I'd like to also thank the members of the public who in fact contributed to the Select Committee process. As Honourable Cosgrove has actually said, Select Committee is actually there to scrutinise the piece of legislation. And I just want to remind the member, you know, he has been here long enough, and often Select Committees meet, we actually examine it. There are things that we may not like, and Select Committee decide. And in this circumstance, the committee as a whole agreed that there are some elements within the legislation that needed to actually exit. And I think, you know, I thank the unanimous decision that we actually made as a committee, and we, in fact, work quite constructively. I think the important aspect of the bill, sir, is actually not the SAP and SCP. It's actually the thing about the implementation of the single Trans-Tasman registrations regime for the patent attorneys in our 2 countries. And I know that you know, we've actually had quite a lot of submissions from patent attorneys who actually worried, actually opposed on the grounds that it would perhaps impact on the competitiveness of New Zealand patent attorneys, that it might in fact increase costs to quality as a patent attorney in New Zealand, that it might actually reduce the you know, the level playing field with Australian patent attorneys. And there were lots of concerns raised by submitters saying that as a country with such small numbers, we may actually lose out to Australian patent attorneys. I think, but the committee actually agreed as a matter of course that in fact that might put us more competitive against the Australian patent attorneys. And I think even in the minority report of the Labour Party actually acknowledges that in the sum of it all, when we actually got to the bottom of it, that it is in fact a benefit of New Zealand and benefit of the competitive nature of it that we were actually supporting it. And I think, you know, having a joint registration implementation of patent attorneys across the 2 countries is something that we actually value and we actually promote and we will actually have. And I think it is a welcome decision. In relation to the SEP and SAP, the single patent application and single examination process be removed, I mean, that was supported, and Honourable Cosgrove has spoken extensively on that particular matter. I now move to the recommendation of the lack of unity of invention grounds issue that I raised previously in my speech in the House. And the issue that some people might actually have is the issue of retrospectively applying it from the date of that Patents Act 2013 entered into force, which is 13th of September 2014. We as a committee did in fact note the undesirability of retrospective law being passed by this chamber. But we also understand that no application on file would be affected by this amendment, and that it is important for any potential applicants to be aware of the potential law change so that there are no challenges based on the unintended provisions currently in legislation over the period between the bill's time in Parliament and resulting passage into law, sir. I think New Zealand patent, of course, gives key intellectual property rights under the under the bill with the recommendations as proposed, we will see stronger protections for patents and the role that patent attorneys across Australia and New Zealand have to play in their development. We believe in ensuring our regulatory regimes are fair and effective for those businesses and companies that utilise them. And I think it was agreed as a committee that, we are here to protect the businesses so they can be competitive, and having a shared regime between Australia and New Zealand will in fact improve the competitiveness of New Zealand's innovative business. So it's a good bill, and I thank the members of the committee for working constructively on this bill, and I commend the bill to the House.